Welcome to 5 at 5 with Stone Law Offices. I'm attorney Brendan Bybee with 5 minutes on trust administration for married couples. When a married couple comes in to set up their estate plan, we're usually doing a joint trust for them. That means both of them are putting their property together into the same trust. They're both trustees and they're both beneficiaries of that trust. When the first spouse dies, there may not be that much that needs to be done because everything's already in the trust. Property passes automatically to the surviving spouse in many forms, and there may not be that much to be done. But that doesn't mean that there's nothing that needs to be done. And so it's very important that once you've taken care of funeral arrangements, settling some other affairs, and dealing with just the initial mourning and getting yourself oriented again, it's important that you see your attorney and that you make sure that you've gotten all the steps of administration done at that time. Like I said, in most cases, there may not be that much to do. Most of the property is joint. It's going all to the surviving spouse in many cases. There may not be any separate debts, but it's important to make sure that we've taken those steps and clarified those things. So for debts, for example, it may be that all the debts are separate, but in some cases, a deceased spouse may have had some other dealings, business dealings, where they could have incurred some separate debts, debts that would not be answerable against the portion of the property that belongs to the surviving spouse, but may only be answerable against the deceased spouse's portion of the property. In any event, we want to make sure that there aren't going to be any surprises, and so it's generally a good idea to publish notice to creditors for the trust, for the estate of the deceased party there. And that's just to make sure nothing's going to come out of the woodwork later that's going to frustrate the surviving spouse or going to take away those assets. We want to make sure that they're cut off. So though in many cases, there may not be those separate assets, it's always much better and more secure to make sure we've cut those off. That way, years down the line, we don't have somebody coming up that says, oh, I have this loan. I loaned your husband, your spouse, so much money, and now I want it paid back. If we've gone through the process, they're cut off and they can't come against you later. So we still want to take care of that process. Other things that may need to be done are taking care of tax matters. Now, when we're doing a joint trust, like I said, in many cases, it may just leave all the property to the surviving spouse. But we often do flexible planning to take account of the fact that tax laws are subject to change and your assets are subject to change. You may find a swing either in the positive direction where your wealth grows a great deal, or it might go the other direction where it's no longer a taxable estate where maybe it was at one time. For that reason, we do flexible planning that allows, in many cases, that allows the surviving spouse to look at things and say, okay, is there some planning I need to do now, given what the laws are at this moment and what the size of the estate is. And these steps, those decisions, do require, in many cases, some affirmative action. In some cases, it may be that the trust is automatically going to do something that we need to keep in mind and decide whether we want it to do that thing or to take advantage of perhaps disclaiming property, putting it into this other tax advantage trust. And those things take some affirmative action. There may also be cases where perhaps the trust all goes to the surviving spouse and we're okay with that, but we want some asset protection and we have to take that affirmative step. In other cases, it may be that the trust automatically divides, and unless you take some action there, you're going to have two different trusts that are going to operate differently, and if you disregard them, can cause some problems down the line. So it's important to go through, look, see what the provisions are, see what the circumstances are at this time, and what affirmative steps we have to take, and your attorney can review that and help you take those steps. But all of this is, again, for the purpose of ensuring that the surviving spouse from that point forward has some predictability about what's going to happen with their estate. They're able to make changes that they may want or need to make at that time. And that they don't end up with a situation that causes conflict later on because they didn't deal with some provision or circumstance in the trust that does something different when first spouse passes away. Though we often think in those marital situations that all the property is one thing. The truth of the matter is there are still two people that are part of that marriage, and they each have some ability to control what happens with that property. And so we still have to deal with possible separate debts and possible other distribution provisions in the trust. Therefore, though you don't have to usually get too bogged down with a lot of individual things when the first spouse passes away, once you've taken care of, like I say, just the initial things, the funeral arrangements and some preliminary mourning, that it's important to see your attorney and make sure you know exactly what's going on, what may need to be done and what maybe doesn't need to be done, so that you can rest easy and know, okay, my estate is still going to continue to roll forward and do what I need it to do. If you have questions about your trust, how it's going to operate when the first of you passes away, or if your spouse has passed away and you're not sure if you've taken those steps with your trust since that time, come in and see us. Let us take a look at things and see what we can do to make sure that your trust works the way that you need it.